Leopoldo Parada from University of Turin. So do I believe that the DST may violate EU law? Well, this is not an easy question, but if we look at the design of a DST from different member states, we can see that there is this use of high revenue thresholds in order to target a specific taxpayer. So, in other words, when we look at the impact of the DST from a domestic perspective, it will basically impact mostly non-national, non-resident companies. It could be a big issue based on nationality discrimination under EU law. But at the same time, we can have issues at the level of state aid, because at the same time that we have a selective tax applied on big companies, we can be bringing a subsidy to smaller companies. And this is of course forbidden under Article 107 of the TFEU. So in both perspectives, from a fundamental freedom perspective and from the perspective of state aid, the DST can actually raise important issues. Could it make any difference whether the DST was actually adopted as a directive instead of being applied unilaterally by member states? Well, in such a case, there could be some differences. First of all, because we have this recognized doctrine of Deutsche Bahn at the level of a state aid, so no state issues could be raised in the case of a DST within a directive. In the case of a EU directive implementing a DST and fundamental freedoms, we have still some questions. First of all, because it is not entirely clear whether the Deutsche Bahn doctrine applied in the case of state aid can be also applied in the case of fundamental freedoms. An intuitive answer could be no, but of course this is still something open. However, generally speaking, we would face, or it would be easy to raise questions about the DST from a unilateral perspective rather than from the perspective of EU legislation.